Hi, welcome everyone, and thank you for joining us today for How to Prepare for the H1B Lottery. We are your presenters, Amy Royalty and Marcia Mavunkel. The presentation will last around an hour with time for questions at the end. Please use the question chat feature on your screen to ask questions. We will do our best to answer most of your questions at the conclusion of the program. At this time, all lines are muted. This presentation will be recorded if you would like to share it with others at a later date. And now we'll just go ahead and jump right in.
Hi everyone, this is Amy Royalty. I'm an immigration attorney at Ryan Swanson. And today we just wanted to talk about the H1B petition process, specifically in conjunction with this 2019 H1B cap lottery, which is coming up, as everyone knows, on April 1st. 2019, and now we're sort of in the home stretch until that filing deadline. So to start, I thought we would talk a little bit about what is an H1B. And H1Bs are temporary work visas that's available for an individual who's working in a specialty occupation. Specialty occupations include primarily professional occupations, such as engineers, scientists, accountants, lawyers, physicians, architects, and some business and marketing or analytical type positions. A specialty occupation is one that normally requires at least a bachelor's degree in a specific specialty field or equivalent work experience. Generally, about 3 years of work experience is considered equivalent to 1 year of education. So the H1Bs are allocated according to a lottery system because Congress has imposed a quota or cap on H1B visas. So for people who have never held H1B status or who have not held H1B status in the last 6 years and are not otherwise exempt from this annual quota, all H1B petitions must be filed on April 1st, 2019. And this is for a start date in the 2020 fiscal year, which starts on October 1st, 2019. The annual quota for H1B visas is 65,000 for individuals who have bachelor's degree, and that can be a U.S. bachelor's degree or a foreign bachelor's degree, and 20,000 additional H1B visas for individuals who hold U.S. master's degrees. So why are we talking about H1Bs now? Well, for several years, H1B visas have been allocated according to a lottery system, with fewer of 50% of petitions filed selected in the lottery in recent years. So as everyone has experienced, there has been a lot of competition for H1Bs, and particularly the lottery process has been a difficult one for employers in the last probably about 5 to 7 years. As we discussed earlier, H1Bs are available for a start date on October 1st, 2019 or later, or for employees who are in F1 status, that's anyone who's a student who has recently graduated and holds either an OPT EAD or a STEM EAD. If that EAD expires after April 1st, 2019, they're eligible for what's called a cap gap. And that allows those students or employees to continue working for the employer until the H1B petition is filed and received and until the approval of the H1B petition. Unfortunately, in the last couple years, USCIS has taken away premium processing for H1B cap petitions. So this means that many petitions have been pending after October 1st. If you have a student who's working for your employer pursuant to the cap gap, meaning that their H1B petition was selected and their OPT expires anytime after April 1st, they are only eligible to work until October 1st. So we have had employees who have run out of that cap gap work authorization because their H1B petition is pending after October 1st. And there's also the OPT STEM extension that's available for employees for an additional 24 months. So if you have a student who has an OPT EAD that expires, you may have the option of filing what's called a STEM extension to obtain an additional 24 months of work authorization for that employee. However, your company must be registered with E-Verify in order to qualify that student for the STEM extension. What we generally recommend is that you go ahead and file an H1B CAP petition for all employees, regardless of when their OPT or STEM extension expires. That's because you want to have multiple bites at the apple. Because of the lottery system, you have no guarantee that your H1B petition will be selected in this year's lottery. So you want to file an H1B CAP petition as soon as possible, and then you may or may not need to file additional H1B CAP petitions in future years if your petition is not selected in the lottery. So who's exempt from this H1B annual quota? Because recently, in the last year, I believe that it was about 190,000 H1B petitions were filed to get the 85,000 total H1B visas available. So it's very competitive and very difficult to secure an H1B in this current system. There are a number of different types of employers who are exempt from the annual quota. First, there are those employees who have been granted an H1B within the last 6 years, if they've not used up the full 6-year duration of their H1B status. This is a really good option if an employee might be in a different status, if, for instance, they attended school after holding H1B status, or perhaps they're on a dependent visa or EAD. They may qualify for or be exempt from the H1B quota if they have previously held H1B status. There's also employees of a U.S. institution of higher education or affiliated nonprofit organization. Those are considered CAP exempt organizations, and they can file H1B petitions for their employees at any time. And other employers that are exempt from the CAP are healthcare providers, and as long as that healthcare provider is affiliated with an educational institution. So now we'll talk a little bit about the H1B process, meaning this is the process that you need to undertake in order to sponsor an employee for an H1B visa, specifically under the H1B CAP lottery. So the most important step for every employer is to register with the Department of Labor. This is why we want to start H1B CAP petitions as soon as possible, preferably within this month, so that we can make sure that this registration process is complete, because it can take up to 3 weeks and potentially longer to get the employer registered with the Department of Labor. This is only required for those employers who have never registered with the Department of Labor and or who have not filed H1B petitions on behalf of their employees. So to register with the Department of Labor, employers must obtain documentation that shows their FEIN, their Federal Employer ID number, and also the name of the employer associated with that FEIN. Such documentation is typically the IRS assignment of FEIN to that company, or a federal or state tax return that has a pre-printed label listing the employer's FEIN. Also, documentation from an employer's financial institution showing the FEIN can also help. In addition to this FEIN documentation, often the Department of Labor requests evidence to show that the employer is maintaining an office or has existing business activities at that location. So we may have to also submit additional evidence such as articles of incorporation, a business license, even utility bills or certifications of business existence. Any other official or government documents can also work in this regard, such as quarterly tax returns if they have a pre-printed label with the company's FEIN. So we typically work with employers to gather that evidence and submit it to the Department of Labor in order to complete that registration process.
Great. So once the company has been registered with the Department of Labor, and generally it takes, I would say, approximately 3 days to hear back if you're registering for the first time, to confirm that the company is now registered, you can move on to the first filing with the Department of Labor, which is filing of a labor condition application, or what we call an LCA. The LCA is an application filed to Department of Labor by prospective employers who are seeking filing of an H1B position. So this employer submission of an LCA ensures that the employment of H1B visa holders will not adversely affect wages and the working conditions of U.S. workers. This is an online submission through what is called the iCert portal. By submitting and signing this LCA, the employer is making certain attestations to the Department of Labor. They are affirming that the employment of this H-1B worker will not adversely affect the wages and working conditions of other workers who are similarly employed in that area of intended employment. They're also agreeing that they will pay this H-1B worker the higher of either the actual wage or the prevailing wage for this particular occupational classification. And in the next slide, I'll go through what those two terms mean. The employer will also notify employees by posting this LCA that the LCA is being filed. The LCA will be posted in 2 conspicuous locations at the place of employment. At the time the LCA is signed, it's also confirming that there is no current strike, lockout, or work stoppage related to any labor disputes in the occupation. And generally it takes approximately 7 days for the LCA to be certified by the Department of Labor. So what are we looking at when we're looking at this LCA? We're looking at the prevailing wage. So the employer can submit this labor condition application as early as 6 months prior to the start date of the employment. So for CAP cases, this is one of the first steps we will initiate. And that generally means that we'll start filing LCAs in January or February. Part of the reason is, of course, if we have a large volume, we want to make sure that we get a jump start on this. Sometimes in years past, because of the large volume of applications that are filed, ICERT has crashed. So the last thing we want is to be waiting until the very last minute and then be faced with the website having been down due to being overwhelmed. So we really recommend getting that first step filed as soon as possible. So as I mentioned previously, this LCA is submitted to the Department of Labor through an online ICERT portal. And it is verifying that the employer is paying either the prevailing or actual wage for the position. So the Department of Labor conducts essentially a market survey. They look at various occupational categories and they look at what we call the metropolitan statistical area, so the area in which that employment is occurring. And then they assign essentially 4 wage levels that determine what are sort of the average 4 wage levels for that particular occupation and that area. The wage levels take into account what level of education is required for the position, the experience, if there are any supervisory duties, or if there are any special skills. So when you work with our team, we go through that, we look at the various occupational categories, we try to find one that most closely matches the position, and then also discuss what the various wage issues are. But those 4 wage levels establish the prevailing wage. Now, if you have another employee who is in a similar position with similar background, education, and experience, and you're paying them a higher wage, or this is considered an actual wage of what you're actually paying employees in similar situations, you'll have to pay whichever is higher, what you're currently paying employees in a similar position or the prevailing wage. And then that is what's called the required wage. In the prior years, we've seen, or actually last year was the first year we've seen USCIS take a really close look at level 1 wage issues. They're really focusing on whether an employee truly should meet only the level 1 wage. Is it actually an entry-level position, or should they be paid a higher wage? And so we did see a little bit more scrutiny on that last year, and definitely want to make sure that the level 1 wage is the appropriate wage to select in any H-1B cap cases. So as I discussed, the employer will post this LCA just before filing at least 2 conspicuous locations at the employee's work site for at least 10 days.
So just a note, we actually prepare what's called a notice of posting. So employers can either post the actual LCA or a notice to employees that they are posting that LCA if they prefer to just post a notice. And they can also list a wage range, so you don't have to list the actual salary on the LCA or notice. You can list a range as long as it starts at or above that prevailing or actual wage, whichever is higher.
So another requirement is that an employer maintains a public access file for each H-1B employee. This public access file must be readily available and accessible to the public and for DOL inspection, and is located at either the employer's principal place of business or the location of employment. And what's included in the public access file, which we generally prepare for you, is a copy, of course, of the certified LCA, that's signed by the employer, evidence that the LCA was provided to the employee, so an acknowledgement or a signature from the employee that they have received a copy, an explanation of how that wage was set, so whether you relied on the prevailing wage or the actual wage, and then a summary of benefits that are offered to workers in similar occupational classifications. And additionally, of course, proof that that labor condition application was posted for the required 10 days in the 2 conspicuous locations. And that's signed by an HR or authorized representative, whoever's conducting the posting.
One thing, we generally prepare public access files for employers, and typically for the H1B CAP process, we've waited to prepare those files until we know a petition is selected in the lottery. You don't need to maintain those files for employees if their petition is filed but not selected, so that's just something to keep in mind.
So looking now at what are the documents that employers generally need to submit for the company. So we have sort of a generic list here of the most common items. Of course, every case is different. There may be additional items that we'll request, but generally we want to provide evidence that the company can pay that prevailing or actual wage. And so we'll include, for private employers, usually audited financials or their U.S. income tax return for the most current year available. And again, this provides evidence to the government that there is enough income to pay that required wage. For public companies, we often will just include the annual report. If a company has over 100 employees, we can also submit a letter from the CFO confirming the ability to pay that required wage. We also want to include information on the company. Most often we'll include items such as website printouts, marketing material, brochures. Often for particular employers, maybe smaller employers, if this is the first H1B, we'll also include evidence that shows that it is sort of a brick and mortar establishment. So we might ask for the lease, we might ask for pictures of the space. Sometimes if the position particularly for smaller companies, we may want to include information on the type of contracts the company is engaged in to show that there is sufficient specialty occupation work available for the full 3 years. And then we also include evidence, or we also confirm with the employer that they've registered with Vibe, which is a company, Dun & Bradstreet, that runs it. This is not an actual requirement per se, but USCIS has been relying heavily on the Vibe system to confirm business existence. And we have seen in the past where a company has not registered with Vibe that we've gotten RFEs, which is a request for evidence, asking, particularly naming Vibe and saying that the employer is not located within it and needing confirmation. And again, it's one of the ways that immigration tries to confirm that an employer is actually doing business and actually exists. So we do recommend that. Okay, so moving on to the employee documents and information needed. So we talked about what the company generally provides. We do coordinate, of course, with the employee and provide them with a checklist of items that we'll need to file with the H1B petition filing. It also provides us with background information for the employee as well to ensure that they meet the qualifications. So a few of the items we have listed here are the most common. We look at their current resume. We also have to submit their degree, diplomas, certificates, and transcripts. As Amy previously mentioned, since H1Bs are for specialty occupations, we do need to prove that the individual is a degreed professional, has equivalent to a U.S. bachelor's or a U.S. master's degree. And anything that's submitted does need to be in English. If it's a foreign degree, we will coordinate to ensure that it is evaluated by an agency to confirm it's equivalent to a U.S. degree. Or if we're relying on, for example, a combination of education and experience, we also use agencies to confirm that that combination is equivalent to a U.S. bachelor's or master's degree. We also often ask for letters from schools verifying that the employee completed all requirements of the degree program if the diploma is not available. So, in terms of completion of the degree that we're relying on, the degree must be completed even if the diploma hasn't been received, all requirements have to be completed for the program prior to filing. So that is something that's very critical, as we've had issues in the past where a student says, I've taken all my classes, I'm all done, I just don't have the diploma yet. And in those cases, if there is something outstanding that would not confer the degree and the requirements be complete until after that April 1st filing date, we cannot rely on that degree. So that's one option, is to get a letter from the school, from the registrar's office confirming completion. And then we talked about third-party evaluations of any foreign degrees or equivalent in work experience. Oops. Oh, here. Okay. So in a little bit more on employee information needed, when we assess the case, we discuss this with the employer as well. We talk about, is this something that we're asking for a change of status? So if an individual is a student in F1 status, essentially what happens as of October 1st is that their status automatically changes to H1B. It becomes effective that date without them having to depart the United States and re-enter. And that's a very common one. And in order to preserve that change of status, that employee cannot travel, cannot depart the United States between the date of filing and that approval period. And sometimes employees decide that they prefer to do consular notification, so that we will get the approval, but in order to activate the H-1B, the individual will need to depart the United States, obtain the H-1B visa, and then return in H-1B status. And the earliest that somebody can return in H-1B status is 10 days prior to the effective date, which would be that October 1, 2019 date. That decision can arise for many reasons. For example, we've had individuals in TN status that want to continue to be able to travel while they wait. And so in those cases, we've decided to pursue consular notification so we don't have to worry about them being locked into staying in the United States. But it is important to note that a change of status is required for any of those CAP-GAP cases that Amy mentioned previously. So for students whose EAD cards are expiring and they're relying on CAP-GAP to continue work authorization until that October 1 effective date, they will need to remain in the United States. So in addition, what we'll include is evidence that that employee has always been in lawful status since arriving in the United States. That will include filing their I-20s that are issued from their schools. If they worked for any period of time through the curricular practical training programs or through OPT, optional practical training programs, we'll include W-2s, pay stubs, just to confirm for immigration that they're always maintaining that F1 status at all times. Another thing that we'll include, if the employee has a spouse or children, and we're filing for those family members as well, our evidence, of course, of their status. Will include any dependent passports, visas, relationship documents to prove that they are, in fact, the spouse and children of that employee. And we'll file an application to change their status as well, which is called an I-539. If an employee has ever previously been in a J1 status, and this is an exchange visitor status, we'll also confirm that they're not subject to what we call a foreign residency requirement. It's the 212E. Some countries require that their J1 students, exchange visitors, first return to the home country for a 2-year period prior to being eligible to change status, and that would include to change status to H1B. There are ways to circumvent that and receive waivers of that requirement. And if that is the case, then we will strategically work with the employee to see if that can happen in parallel and if the H-1B can still be filed. But it is an important issue to spot up front because in certain situations, an employee may be more or less likely to get that waiver. For example, oftentimes Fulbright scholars are ineligible to waive that 2-year requirement. Or if there's government funding, that's also a difficult one to waive. So these are some of the documents we'll ask for and issues that we'll spot when we're assessing the H-1B.
Okay, so we've talked about employers, employer information needed, job information needed. Now that's what we're moving on to. We talked about what we need from the employee, and all of this can take time. So often it takes us at least a few weeks, if not longer, to gather all of this company and employee evidence. But the most important part of the process is obtaining the job information, because it is very important in order to show that an employee qualifies for H-1B status that we show that the position actually qualifies as a specialty occupation and that the employee has a degree in a specialty field that is related to and required by that occupation. So what type of information do we need about the job? First of all, we need a detailed job description. We can rely on the company's internal job description, but one thing to keep in mind is that it must list an education requirement, and it should list at least the education requirement of at least a bachelor's degree in a specialty field that's related to the position. If the job description states bachelor's degree preferred, or bachelor's degree but would consider degrees in other fields, then that may be an issue, because we often need to submit that internal job description in support of the H-1B petition. So that's just something to keep in mind as you create and work with your HR teams on these job descriptions. The other information that we will need to gather immediately would be the offered salary and the salary range for the position. We will use that to prepare that LCA, which needs to be filed and certified before we can draft and finalize the H-1B petition. And then finally, what other evidence do we need to show a position qualifies as a specialty occupation? Typically, what we've seen in recent years is that this is the sort of issue du jour of USCIS. This is the major issue that we're seeing a lot of requests for evidence, and even hearing about denials of other H-1B petitions on the basis that the position does not qualify as a specialty occupation. So we work closely with employers in making sure that we have sufficient evidence to show that the position qualifies as a specialty occupation. I would say the jobs that have been a real issue in recent years is analyst positions, graphic designers. We're also seeing it with business and marketing positions. Anything in sales, that type of position can be an issue, particularly if the employee only has a business degree, or God forbid, a liberal arts degree, which is of course my degree field for undergrad. I don't think I would have qualified for an H-1B when I was graduating from college. But other types of positions, even technical positions like product managers, have been a challenge. So we typically do work with the employer in gathering additional evidence for these types of positions to show that the position requires a bachelor's degree. One thing that we found works well is including a job duties chart. That is something where we can show that we actually typically work with the employee to show how the coursework that employee completed during their bachelor's or master's program is related to each of the job duties of the position. So we may need to get more detail from the employer or the manager on the specific job duties in order to work with the employee in gathering that information. We also can submit job postings from other employers in the field, because one of the criteria for showing a position as a specialty occupation is to show that it's normal in the industry to require a bachelor's degree for that specific position. And then industry or university letters are similar. We have used expert opinions. They typically are costly. They can cost anywhere from about $500 to $1,000. And recently we've seen that USCIS is applying a high level of scrutiny to the expert opinions. So we generally try to include evidence from industry, university, even from the specific employer to show that a bachelor's degree is normal to the position, that the employer normally does require a bachelor's degree for this position, that other employees in that position within the company do have a bachelor's degree or higher in this specialty field, and that also it is normal to the industry to require a bachelor's degree. So there's a lot of criteria, and even though we're only supposed to be required to show one of the criteria to qualify an employee for H-1B status, what we've seen on the request for evidence from the Immigration Service is that they want us to show that the employee meets every criteria. So we do our best to submit a lot of evidence up front in order to avoid that request for evidence and obviously, any possible denial of the H-1B petition. So what are some common oversights and issues or things that can come up and potentially derail the H-1B process? As Marcia mentioned, if someone's held J-1 status, they may be subject to a 2-year foreign residency requirement, and in that case, they would not qualify for a change of status to H-1B. We have had certain, employees who are applying for a J1 waiver, and if they've applied for a J1 waiver, then we can at least file the H1B petition, but we would make a request for consular notification, since they need that J1 waiver in order to secure the H1B visa and start working in H1B status. The other important issue that's come up recently has been F1 status issues. USCIS issued a new memo in August or September? In August, and it basically has changed the rules on when a student can accrue unlawful presence. It's made it much more difficult for students to be eligible to change their status automatically to another status like H1B, but it also subjects foreign students to the possibility that they could accrue unlawful presence and potentially be barred from either staying in the U.S. and working or re-entering the U.S. if they travel abroad. So we want to look closely at F1 students and their status and make sure that we have, sufficient documentation to show that they've maintained lawful status in the U.S. during their entire period in F1 status. One kind of red flag that we've seen is F1 students who are working full-time pursuant to CPT authorization. USCIS is really scrutinizing CPT, particularly if the employee has already used up 1 year of OPT. A lot of times employees might enroll in a second master's degree program in order to get full-time CPT, and basically it's sort of a way around the H1B petition requirement. And so USCIS has definitely caught on to that, and we will notify employers if we see that that's an issue, but it's also something to note if in the recruitment process or you're working with an employee and they are working on that full-time CPT, you do want to raise that issue with your immigration counsel. Also, if you have an employee who's working on CPT, they wouldn't be eligible for that gap work authorization, allowing them to work if the H1B petition is selected. So you just want to watch out for that. The only employees that are eligible for the gap are those who are working on OPT, so post-completion OPT EAD, or a STEM EAD. Another issue that comes up that we don't talk about a whole lot is the deemed import-export control laws. And the H1B petition does have questions specifically about this, and employers do need to check the box and attest whether or not compliance with import-export laws is required and whether they have met that requirement, basically. I think it kind of has to do with disclosure or access to technology or sensitive technology and transmission of that technology to the employee. So, for instance, if an employee is a national of certain countries like Iran or one of the countries listed on the travel ban, they may be subject to that import-export or deemed export control laws, and you would have to confirm that with your export counsel because we don't actually have expertise in that area. So that's something that we ask you to sort of verify up front, and it's just something to consider. And then finally, as Marcia mentioned, you want to make sure that your employer's information is up to date on the Dun & Bradstreet system. Mainly that's sort of if you've changed offices or moved or you've opened new offices in the US, or it's an office the employee is going to be working at is a branch office of your headquarters. You want to make sure it's listed on that Dun & Bradstreet system because it is possible USCIS will use its FIBE system and then issue a request for evidence if they see a work location that's not listed on the Dun & Bradstreet website. Oh, if anyone has any questions, please do write, I think you can mark them in the box on the left-hand corner of your screen and submit them now because we will be gathering the questions and we can answer them at the end of our presentation. We're sort of reaching the home stretch, so just a few more slides and then we can address any questions anyone has. Oh, okay, so, we're going to talk about offsite employment. So offsite employment is basically employment where the employee is working offsite at a client site and they're not working at your office, so at the company's office that's sponsoring them for an H1B. So USCIS has scrutinized offsite employment for many years, but certainly under recent immigration policies, specifically this memo from the president called the Buy American, Hire American, order, they are placing even a higher level of scrutiny on off-site employment. So to show that someone qualifies for H1B, USCIS requires that we demonstrate there's an employee-employer relationship between the company and the employee. And so if there's a third-party placement arrangement with it where an employee is working off-site at a client site, we will need to submit substantial additional evidence to show that they have the H1B petitioner employer has that employer-employee relationship with the employee. We have to show that the employer has the right to control over when, where, and how the beneficiary performs the job. That's the basic standard that we need to show to meet this requirement.
It's also important to raise this issue at the start of a case because there will be requirements on the labor condition application. We'll have to list the off-site location, and the wages can be different if it's in a different metropolitan statistical area. So if that employee is working, the employer's based in Seattle, but the location's in California. So these are crucial issues to raise at the start of a case so we can assess that for you as well.
And also on the off-site issue, if there's multiple locations, so sometimes employers don't know where employees might work. If there's multiple client sites, we should list all of those client sites on the LCA. And if we need to add another client site or work location, that's possible without filing an H1B amendment, but only if the new work site is located in the same metropolitan statistical area. So you want to make sure to cover any and all possible work sites and list those in the LCA and H1B petition if possible. So in terms of evidence needed to show the employer-employee relationship for off-site employment, most importantly, we would need to prepare what's called an itinerary of service. This can either be something that you have internally or we can prepare and then you would fill in the information. We have a lot of samples that we've used of itineraries. We need the signed employment agreement, the offer letter, any other type of evidence showing that this employee will be treated as a full-time employee for purposes of the employment arrangement. W-4 form, employee benefits package, because basically to show that employer-employee relationship, we need to show the H1B employee will receive full-time employee benefits just like any other full-time employees at the company. And then importantly, USCIS now requires that we submit statements of work, any work orders, service agreements, and most importantly, they require an end client letter with the third-party clients. This has been an issue because there's a lot of clients who don't want to provide the end client letters, and unfortunately, USCIS now requires this, and we're unable to file an H1B petition if we cannot secure that signed end client letter from the customer or client where the employee will be working. And then the other information we would need is the job description and documentation that shows the skills required to perform the job, instruments and tools needed to perform the job, product or service to be provided, and the location where the employee will perform the duties. So typically for this, we would include employee work product, evidence that the employer, the H1B sponsor, is going to be providing the employee with the tools needed to perform the job. That's even a laptop or a workspace at the employer's office. Even if they're working most of the time off-site, they do have that workspace at the employer's headquarters or other office. And then show evidence that the employee will be supervised by a supervisor located at that H1B employer. So we typically can include performance reviews, or if that's too sensitive or confidential, even just a description of the performance review process. Org charts are helpful to show that the employee does have a supervisor assigned to him or her within that H1B employer. And then one thing to note that's been a real challenge for us recently is that USCIS is only approving these H1Bs until the expiration of the statement of work. If the company has had ongoing contracts with the client, let's say for many years, pursuant to a services or master services agreement, and we can show that they will keep continuing that ongoing work for the client, either through the client letter or through other evidence, we can typically secure, H1B approval beyond the expiration of the contract. So that's helpful. So I guess what I would say is buyer beware on offsite employment. but it is feasible. Just know that we will need additional evidence and that we want to start preparing those petitions as soon as possible to make sure we have time to gather all of that necessary evidence.
So looking now at what are the fees and the filing requirements and timelines for the H-1B cap case. It's important to note that all H-1B fees and costs must be paid by the employer, and that is required by law. The only exception to that rule has been where premium processing is available, in which case if it's not a business necessity, the employee can pay that premium processing fee. But generally, the filing fees are a base fee of $460, a $500 anti-fraud fee, and either a $1,500 or $750 training fee, and that depends on if the number of employees in the United States, if it's more or less than 25. The premium processing fee is now $14.10, and it is important to note that premium processing has not been available for the last 2 years. So in this last H-1B cap season, it never became available at any point and continues not to be available for any cap cases, and there's that suspension through February 19th of 2019. 2 years ago, premium processing was not available for filing, but then in September, USCIS allowed employers to interfile. So unfortunately, we do not know if it will be available this year. Until told otherwise, we assume it may be, and we do recommend generally that employers do file with that expedite fee. Normally, the premium processing fee guarantees a response within 15 calendar days. For H-1B cap season, it's not quite that fast, but I would say you would see if it's available a decision within 4 to 6 weeks. So that is significantly faster. So let's talk about the timelines. Once the cases are filed, we usually will see if the cases have been selected in a 3 to 4 week period. And that's when we'll get the receipt notices indicating selection. If premium processing is available, we'll get those via email. Otherwise, what we're looking for are hard copy receipts to come in through the mail. Rejection, so if immigration rejects it, they did not make it through the lottery, we'll get the entire packet back, including all the filing fees. And we saw that in this last year, those rejections started coming back to us in about June or July. In terms of approvals, we started seeing those roll in this past year around August. And unfortunately, we still even have a handful of cases that have yet to be decided. So we still have approvals that have not come in. And that's not uncommon. And I think we could probably expect that this year again. So what are the options if your employee's case is not selected? We talked about STEM, that 24-month extension of the EAD for individuals that qualify for E-Verify employers. Oftentimes that filing period for STEM, which does need to be filed prior to their EAD expiring in the 90-day window prior to the EAD expiring for their initial OPT, we just recommend filing it as a safety net. In the best case scenario, the H-1B is selected and approved. In the worst case scenario, you have that as a fallback option. And again, if you wait for that EAD to expire, then they're no longer eligible for the STEM. Other work visa options may depend on that employee's country of nationality or citizenship. We have the TN, which is a work visa through NAFTA, available for clients who have citizenship in Mexico or Canada. That is a little bit limited, though, because there are a list of occupations that qualify, so we would have to assess that eligibility. Australian citizens, there is the E3. It's very similar in terms of the qualifications. It does still have to be a specialty occupation, but it's only limited to Australian citizens. That quota is pretty much never filled, so that's generally always available. If the student wants to enroll in a higher degree program, that's another option. Sometimes students will enroll in a new program and be immediately eligible for CPT, which is employment that provides academic credit. So that's another option. If the individual is sort of at the top of their field, has a lot of awards, is recognized nationally or internationally, we may look at something like an O1, which is an extraordinary ability visa, a non-immigrant visa. And that is becoming something that we utilize more and more as these other categories become tougher to obtain. If the employee has worked for your company at a affiliated branch, office, subsidiary abroad for at least 1 year in the last 3 years in either a managerial or specialized knowledge role, we may want to look at an L1, intercompany transfer. And if they haven't, sometimes employers are opting to say, why don't you go ahead, move to our office abroad, complete that 1 year or longer, and then we'll bring you back in the L1 position. So that could be an option as well. Additionally, if that employee is from Chile or Singapore, there is the H1B one. Like the E3 for Australians, also requires a specialty occupation, also a quota that's never hit, so it's generally always available. And it's similar in some of the processes in terms of filing an LCA and other things. Although it doesn't have the 3-year grant, it's generally an 18-month grant, but renewable. If your employee is married, we may want to look at if there are any work authorization options as a dependent. So if their spouse is on an L1, there is an EAD, an employment authorization card available for spouses under the L2, the dependent spouse category. H4, if they're married to an H1B, an individual in H1B status with an approved I-140 immigrant petition, they may be eligible for the H4 EAD, although the caveat to that is that we are expecting that the H4 EAD category will be eliminated, although we don't have a specific date determined yet. And then other options are looking at if they may already be a U.S. citizen, and that has happened. You'd be surprised where we've had situations where we've realized that somebody's one parent was a U.S. citizen, and we can look at if they have already derived citizenship and did not know it, or if a green card's an option. And the green card process can take some time depending on which process we're implementing. But if the individual has a STEM EAD, we may want to just start that green card process and be able to get work authorization for them prior to their EAD expiring. So some things to consider. And then quickly, before we move into the Q&A or answering those questions you've submitted to us, we wanted to just talk about this pre-registration that's been out there right now. So currently, as of December 3rd, 2018, the Department of Homeland Security has issued a notice of proposed rulemaking to establish a pre-registration system. And essentially what this would do is it would require U.S. employers to pre-register for the cap. And the purpose of this program is to reduce costs to both immigration and employers, as well as to increase selection of foreign nationals that possess a master's degree. So at this point, that pre-registration program has not been implemented. I believe that the notice and comment period has just concluded, but the registration, sort of just the layout that they've proposed is that employers would first register electronically during a designated registration period. It would begin at least 14 calendar days before the first day of H1B cap filings for the next fiscal year, so that April 1 date. And this would be extended if it wasn't sufficiently filled, but generally speaking, that registration would be the first step for employers, and you would separately then register any foreign national that you intend on submitting an H1B case for. And you would provide some basic information on both the employer and the foreign national, including how they qualify, if they qualify based on having the equivalent to a U.S. bachelor's or a U.S. master's. And then once the registration period is closed, then the lottery would occur, and those that were selected would be notified by CIS. And then employers would be given a 60-day period to file that H1B cap case for adjudication. So again, the thought is that this would be cost-effective, and it would also be changing that lottery selection process, where currently what we see is that CIS starts with the master's cases. Those are U.S. master's degree holders. That 20,000 is first selected. Then they go into the 65,000 bachelor's degree holders. And that process would be reversed. So essentially what they would do is first pull the 65,000 and then select the 20,000 master's degree holders. And the idea is that this would increase the amount of master's degree, U.S. master's degree holders that are selected by an estimated 16% increase. It would be important, of course, for employers who register and submit names to actually then follow through in submission of H-1B, because they will be closely monitoring the system for any potential fraud. But again, as of now, we are not seeing that this is being implemented. We are proceeding forward with preparing CAP cases as we always normally have for that April 1 submission date. If anything changes, we will, of course, send out an alert and notify employers that we're working with.
So as you can see, there are some challenges in the current climate for H-1B petitions, and also it can be a difficult process to navigate for employers. But we at Ryan Swanson are very familiar with this process. We're happy to answer any questions you have and navigate this process for both the employer and the employee to make sure that you feel prepared and that you're able to secure this important work visa option for your employees, because it really is still a great option for certain types of positions, and the process doesn't have to be quite as daunting as it may seem if you work with our office. I guess that's all we have for today. Thank you so much for joining us, and please feel free to send us an email or give us a call if you have any other questions after this presentation. And I hope everyone has a great day and very good luck with hopefully a very high selection rate in the H-1B lottery this year. Thank you.